Good morning. We'll be on the record. State of Idaho versus Brad Compher, CR 2014-12727. We have Jonathan Radford, Brian Trammell, Janice Price for the state, Gary Proctor, Scott Andrew, and Riley Fry for the defendant, and the defendant present in the courtroom. We are outside the presence of the jury. Over the weekend, the court sent the parties the final clean set of the jury instructions. The court received emails from the defense regarding renewed objections and some new ones. The court has reviewed the emails which appear to the court to be culminated in the objection to proposed post-evidence instructions filed by the defendant on March 3rd, 2024. Is that correct, Mr. Andrew? Yes, sir. Okay. All right. Well, first, before we take that up, just a reminder, I've allotted 1 hour for both parties for closing arguments. Just a reminder to the state that is 1 hour total, so you need to divide up how much time you want for your initial opening argument and any you want, if any, for a rebuttal. All right. Has the state had a chance to review the defendant's written objection previously stated by the court?
We did, Your Honor.
Okay. All right. Well, the court has, again, reviewed the objections. Mr. Andrew, you want to make any additional argument?
I will turn it over to Mr. Proctor with regard to the limiting instruction. I'll just stand on what was in the written filings.
All right. Go ahead, Mr. Proctor.
Thank you, Your Honor. I did over the weekend have a chance to review the Idaho law, and I cited to the court, and it's in our pleading. There's no need to reiterate it. Rudabout is my best guess on how to pronounce it. You know, the Rudabout case says that one witness commenting on the truthfulness of another witness is not admissible. In this case, we did not object to the statement of the police coming in, and I recall two things he said. One is, the first he said, I think you're being as truthful as you can be, in the context of you're telling me stuff that's not going to hurt you, but you're not willing to tell me the rest of it. And then later on he said, you're just not being truthful. We believe those statements were admissible, which is why we did not object, but only to color Mr. Compher's response to it. And it's kind of like, Judge, when the instruction you're not giving about Mr. Compher having context with law enforcement, we made the decision not to ask for the limiting instruction at the time the statement was played because it would only draw attention to it. But now in the context of a body of instructions, we believe, pursuant to Idaho Rule of Evidence 105, that limiting instruction, I think Mr. Andrew put in his pleading, it's proposed supplemental instruction 5 he put. I think it's 6, I think. So we would ask the court to give defendants proposed supplemental instruction 6, which just sets out Mr. Compher's answers of the evidence, not the police officer's statements.
All right. State's response?
Well, Your Honor, the Rudabout case, I looked into that a little bit. That was, the issue in that case was that there was an opinion that was elicited from the stand as to that witness's opinion of the credibility of another witness. That's not the situation that we have here. The situation that we have here is a recorded interview where there's a back and forth between an officer and a suspect, and the officer made these statements in furtherance of that conversation. So I don't think that the evidence that we're talking about here rises to quite what happened in Rudabout. There was no objection. I think that the jury is able to gauge the credibility of that statement and make their own determination as to its weight. That's the state's position.
Thank you, Mr. Radford. Mr. Proctor, any further argument?
When the jury hears a police officer say, I don't think you're being truthful, I don't think it much matters whether it comes from the stand or a video. If anything, it would be better from the stand because he could be cross-examined on saying that statement in the stand and impeached with evidence to suggest that Mr. Compher was in fact being truthful. Whereas playing the video as a fait accompli is much harder, and a statement that was made 10 years ago is that much harder to clarify during a trial. So I see no basis for a distinction between something a police officer said on a video and something he says in court, and we would continue to ask for the instruction.
Thank you, Mr. Proctor. The court has reviewed State versus Raudebaugh, R-A-U-D-E-B-A-U-G-H. It's 124 Idaho 758, a 1993 case. And Mr. Proctor, you stated a moment ago that Exhibit 36, which is what we're talking about here, was admitted without objection by the defense. And the court was not apprised of any requested limiting instruction at the time that exhibit was admitted. And so, again, for the reasons, in addition to the reasons previously stated by the court at the formal instruction conference, defendants requested number 6 shall not be given to the jury. Now, Mr. Proctor, you also emailed and had a question as to whether Exhibit 36 was going to be available for the jury during deliberations. It will be. Since that was an admitted exhibit, it shall go to the jury and be available to them to review during deliberations.
Thank you, Your Honor. I wasn't clear on that. I guess my question is, because it was redacted, and will they just have a CD and a blank computer back there that they can watch, or will they be brought into the courtroom? What
we've done in the past is the state has a wiped computer that has nothing on it. The jury will use as a medium to play any video.
Yes, sir.
Okay. All right. So again, the court has reviewed the defendant's written objections regarding the use of Ralph Roy Compher, a.k.a. Brad Scott Compher, in the instructions, the use of any felony. Again, for the reasons previously stated by the court, the formal conference on Friday, the instructions 15, 16, 19, 16, 17, and 18 will be given to the jury again, as provided in the clean set of instructions court has provided the parties. As to instruction 17 and 20, the defendant's redundancy argument, again, the court has reviewed those instructions, specifically 16 and 17, 19 and 20 as raised by the defendant, and the objections are noted. They are overruled. Again, the court finds instructions 16 and 17, 19 and 20 correctly state the law. The court does not find them redundant or cumulative. Therefore, the objections again are noted and overruled. Well, the instructions, again, 16, 17, 19 and 20 shall be given to the jury as provided by the court to the parties, again, in the clean set of instructions previously provided. Right, I think that takes care of all the issues. Is there anything else, counsel, we need to take up before we bring the jury in?
Not from the state, Your Honor. We will have to grab the exhibits for closing argument.
Okay. Anything from the defense?
No.
No, sir.
All right. So who will be giving the closing arguments for the state?
I will, Your Honor.
Okay, Mr. Radford, then from the defense, Mr. Proctor. All right, gentlemen. Okay.
Your Honor, it's okay if we grab the exhibits before the jury comes in?
Sure. You want all of them?
No.
Well, we need those photographs, so. 11J, 11I, and 11C. 11J, 11I, 11C, 11M. M, and 11B.
Oh, really? Okay.
B as in boy.
Okay.
Those are the fingerprint cards, and you have 4.
Okay. Little late. Okay. All right, well, we'll take a recess to let counsel figure out which exhibits they want. The juries are still slowly trickling in from the wonderful weather outside, so we'll be in recess.
All rise for the court.
Please be seated. record. State of Idaho versus Brad Compher, CR 2014-12727. State counsel present, defense counsel present, as is the defendant. Told all members of the jury have returned to the jury room. We are outside the presence of the jury at this time. Anything we need to take up, counsel, before we bring the jury in?
Not from the state, Your Honor.
Your Honor, my only question is, at the end of your jury instructions, do we need to renew our objections, or is what we've stated sufficient already?
As far as the jury instructions, you've already made your record.
Thank you.
All right, Mr. Reiner, bring the jury in. Please be seated. All right, good morning, ladies and gentlemen of the jury. I hope you had a good weekend and didn't spend an inordinate amount of time removing snow like I did, hoping for a early spring. All right, all members of the jury have returned from the evening recess, seated in the jury box. Will the parties waive roll call of the jury?
Yes, Your Honor.
Yes, sir.
All right, ladies and gentlemen of the jury, I have some more instructions to read to you at this time. You have copies with you. You're invited to read along if you wish to do so. Instruction number 12. You have now heard all the evidence in the case. My duty is to instruct you as to the law. You must follow all the rules as I explain them to you. You may not follow some and ignore others. Even if you disagree or don't understand the reasons for some of the rules, you are bound to follow them. If anyone states a rule of law different from any I tell you, it is my instruction that you must follow. Instruction number 13. As members of the jury, it is your duty to decide what the facts are and to apply those facts to the law that I have given you. You are to decide the facts from all the evidence presented in the case. The evidence you are to consider consists of sworn testimony of witnesses, exhibits which have been admitted into evidence, and any facts to which the parties have stipulated. Certain things you have heard or seen are not evidence, including arguments and statements by lawyers. The lawyers are not witnesses. What they say in their opening statements, closing arguments, and at other times is included to help you interpret the evidence, but is not evidence. If the facts as you remember them differ from the way the lawyers have stated them, follow your memory. Testimony that has been excluded or stricken, or which you have been instructed to disregard, anything you may have seen or heard when the court was not in session. Instruction number 14. A defendant in a criminal trial has a constitutional right not to be compelled to testify. The decision whether to testify is left to the defendant, acting with the advice and assistance of the defendant's lawyer. You must not draw any inference of guilt from the fact that the defendant does not testify, nor should this fact be discussed by you or enter into your deliberations in any way. Instruction number 15. In order for the defendant to be guilty of first-degree murder in the perpetration of or attempt to perpetrate a felony, the state must prove each of the following. 1. On or about the 27th or 28th day of September 2004, in the state of Idaho, the murder was committed in the perpetration of or attempt to perpetrate rape or burglary. To prove Ralph Roy Compher, a.k.a. Brad Compher, guilty of first-degree murder in this way, the state does not have to prove that the defendant intended to kill Nori Jones, but the state must prove that during the perpetration or attempt to perpetrate burglary or rape, the defendant killed Nori Jones. If you find that the state has failed to prove any of the above, you must find the defendant not guilty of first-degree murder. If you find that all of the above have been proven beyond a reasonable doubt, then you must find the defendant guilty of first-degree murder. Instruction number 16. In order for the defendant to be guilty of burglary, the state must prove each of the following. 1, on or about the 27th or 28th day of September 2004. 2, in the state of Idaho. 3, the defendant, Ralph Roy Compher, a.k.a. Brad Scott Compher, entered the residence of Nori Jones. And 4, at the time entry was made, the defendant had the intent to commit any felony. Instruction number 17. Burglary is defined as follows. Every person who enters any house with the intent to commit any felony is guilty of burglary. Instruction number 18. The manner or method of entry is not an essential element of the crime of burglary. An entry can occur without the use of force or the breaking of anything. The intent to commit any felony must have existed at the time of entry. Instruction number 19. In order for the defendant to be guilty of rape, the state must prove each of the following. 1, on or about the 27th or 28th day of September 2004. 2, in the state of Idaho. 3, the defendant, Ralph Roy Compher, a.k.a. Brad Scott Compher, caused his penis to penetrate, however slightly, the vaginal, oral, or anal opening of Nori Jones, a female person. And 4, she resisted, but her resistance was overcome by force or violence. Instruction number 20. Rape is defined as the penetration, however slight, of the oral, anal, or vaginal opening with the perpetrator's penis accomplished with a female where she resists, but her resistance is overcome by force or violence. Instruction number 21. You may have heard testimony during this trial that the defendant had contact with law enforcement. I instruct you that you are not to consider or speculate as to the reason for the defendant to have come into contact with law enforcement. It should not form any part of your deliberations. Instruction number 22. You have been instructed as to all the rules of law that may be necessary for you to reach a verdict. Whether some of the instructions will apply will depend upon your determination of the facts. You will disregard any instruction which applies to a state of facts which you determine does not exist. You must not conclude from the fact that an instruction has been given that the court is expressing any opinion as to the facts. Instruction number 23. I have outlined for you the rules of law applicable to this case and have told you of some of the matters which you may consider in weighing the evidence to determine the facts. In a few minutes, counsel will present their closing remarks to you, and then you will retire to the jury room for your deliberations. The arguments and statements of the attorneys are not evidence. If you remember the facts differently from the way the attorneys have stated them, you should base your decision on what you remember. The attitude and conduct of jurors at the beginning of your deliberations are important. It is rarely productive at the outset for you to make an emphatic expression of your opinion on the case or to state how you intend to vote. When you do that at the beginning, your sense of pride may be aroused and you may hesitate to change your position even if shown that it is wrong. Remember that you are not partisans or advocates, but are judges. For you, as for me, there can be no triumph except in the ascertainment and declaration of the truth. As jurors, you have a duty to consult with one another and to deliberate before making your individual decisions. You may fully and fairly discuss among yourselves all the evidence you have seen and heard in this courtroom about this case, together with the law that relates to this case as contained in these instructions. During your deliberations, you each have a right to re-examine your own views and change your opinion. You should only do so if you are convinced by fair and honest discussion that your original opinion was incorrect based upon the evidence the jury saw and heard during the trial and the law has given you in these instructions. Consult with one another. Consider each other's views and deliberate with the objective of reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. However, none of you should surrender your honest opinion as to the weight or effect of evidence or as to the innocence or guilt of the defendant because the majority of the jury feels otherwise or for the purpose of returning a unanimous verdict. Instruction number 24. The original instructions and the exhibits will be with you in the jury room. They are part of the official court record. For this reason, please do not alter them or mark on them in any way. You each have a copy of the jury instructions, and you may mark on your copy if you wish. The instructions are numbered for convenience in referring to specific instructions. There may or may not be a gap in the numbering of the instructions. If there is, you should not concern yourselves about such gap. There is no official transcript of the trial proceedings that you can refer to. You must rely on your memory and your notes of the testimony. No portion of the testimony will be available to review, so do not expect that. Instruction number 25. Upon retiring to the jury room, select one of you as a presiding officer who will preside over your deliberations. It is that person's duty to see that discussion is orderly, that the issues submitted for your decision are fully and fairly discussed, and that every juror has a chance to express himself or herself upon each question. In this case, your verdict must be unanimous. When you all arrive at a verdict, the presiding officer will sign it and you will return it into open court. Your verdict in this case cannot be arrived at by chance, by lot, or by compromise. If, after considering all of the instructions in their entirety, and after having fully discussed the evidence before you, the jury determines that it is necessary to communicate with me, you may send a note by the bailiff. You are not to reveal to me or anyone else how the jury stands until you have reached a verdict, or unless you are instructed by me to do so. A verdict form suitable to any conclusion you may reach will be submitted to you with these instructions. All right, is the state prepared to give closing argument?
We are, Your Honor.
You may proceed, Mr. Radford.
Your Honor, just before I get going, I'll inform those in the gallery that we will be demonstrating some exhibits. Some of those exhibits will be graphic and difficult.
Thank you, Mr. Radford.
Ladies and gentlemen of the jury, I thank you for the time that you've taken out of your lives to participate on this jury, and for the attention and for the candor that I know you will exercise in your deliberations. Trial by jury is a foundational element of our republic, and your role as a juror is sacrosanct. It is for you to weigh the evidence, to gauge the credibility of the witnesses that you have heard, and it is for you and you alone to decide whether Brad Compher killed Nori Jones. Punishment is for the judge, and you don't need to worry about that. The only thing you have to decide is whether Brad Compher is guilty of first-degree murder. As you deliberate, you're going to see a number of instructions. One of the instructions you will see is on the burden of proof. As you are already aware, the burden of proof in this case is beyond a reasonable doubt. The state must prove the elements of this crime beyond a reasonable doubt. But I want to make it clear to you that we are talking about reasonable doubts. We are not talking about fanciful or imaginary doubts, or doubts based on sheer fantasy. A reasonable doubt is one based on reason and common sense. Reason and common sense. In the law, we focus so much on fine, precise analysis. But this decision that you have to make is specifically given to members of the public, to the defendant's peers, precisely for that reason. Jurors, much more so than lawyers, can be relied upon to exercise common sense. So while I urge you to be careful and deliberate in your decisions, don't overthink this. Use your common sense. Brad Compher is charged with killing Nori Jones under what is called the felony murder rule. There are crimes that are simply so dangerous and inherently risky that the state legislature has seen fit to say that if a person commits or attempts to commit those crimes, for our purposes here, burglary and rape, and that person kills another person while doing so, then that murder is murder in the first degree. And the state does not have to prove that the killing was intentional. Now, that does not mean that if you find the murder was intentional in this case, that it doesn't fit. The intent to kill is simply something the state does not have to prove and you do not have to consider. Now, when you look at your instructions, you will see that the state must prove that Brad Compher killed Nori Jones in the perpetration of rape or burglary. I'm going to ask you to carefully pay attention and note what I am about to explain. The term perpetration has a specific legal meaning here, specifically when it is tied to burglary. And here's what it means. When a person commits burglary, it sets in motion a stream of events or a criminal episode. And if a person is killed during that stream of events or that criminal episode, then it is murder in the first degree. Burglary is committed when a person enters a house with the intent to commit any crime that is designated as a felony under our law. Rape is one of these. As you will read in your instructions, rape is defined as the penetration, however slight, of the oral, anal, or vaginal openings of a woman with a penis when the woman resists and the resistance is overcome by force or violence. But in order to decide that a burglary occurred, you don't need to determine that Brad Compher had the intent to commit rape or even committed rape when he entered that house. Burglary is the entering of a house with the intent to commit any felony. Stabbing or cutting somebody with a knife is a felony. That is called aggravated battery. Forcefully removing property from a person is also a felony. That is one form of grand theft.
Your Honor, we have to object to this.
Your Honor, we've been over this.
All right, counsel, I'm going to sustain the objection, okay? So continue
The
on.
instruction that the jury will hear is any felony.
That's correct. But we have gone over this, Mr. Radford, so please continue.
So pay attention to what I said about rape. Now, I want you to pay particularly close attention to how the felony murder rule works in relation to burglary. In State v. Federally, a case that when it comes to burglary is very similar to the facts you have in front of you.
Your Honor, I would object. We're citing case law. That's your province.
I can't cite case law to the jury, Your Honor. Case law is mandatory law.
Well, I'm instructing the jury it's the law, Mr. Radford. So, again, please continue with your closing remarks.
Just remember, when you are deliberating, that if you decide Brad Compher climbed in through that window with the intent to rape Nori Jones, and he killed Nori Jones while he was in that house, then her death was in the stream of events that began when he entered the home, and it is murder in the first degree, and you must find him guilty. Also, regardless of what you decide on the burglary, if you decide that Brad Compher killed Nori Jones as he raped her, or as he attempted to rape her, then it is also murder in the first degree. You do not have to find that he did all three, that he attempted to rape Nori, and committed burglary when he entered the home. It can be just one of them. You can decide he didn't rape her or attempt to rape her and still find him guilty of first-degree murder because he killed her in the stream of events that began when he entered the house with the intent to commit a felony. Or you can find him guilty because he killed her in the perpetration of raping her or attempting to rape her. Or you can find that he did all of those. That is how the law works. And ladies and gentlemen of the jury, that is exactly what happened. Brad Compher killed Nori Jones in the stream of events that began when he climbed through that window and in the perpetration of her rape. That is what happened. I'm not sure if you've seen an Impressionist painting before, something by Monet or Manet or even Van Gogh. If you stand real close to the canvas, all you will see is little multicolored dots. You won't see any brush strokes. It's only when you take a step back from the canvas that you can see the full picture. Those dots combine to give you the clear picture. Evidence in a criminal case is often like that. You don't just consider one piece of evidence in isolation. You consider the entire picture. You look at the whole thing. It's easy to poke holes in isolated pieces of evidence. But when you consider all of them together, that's when you get the full picture. In what I will argue to you today, I will not ask you to disregard or discount a single piece of evidence. I will ask you to consider all of it and see how it fits together. You will not arrive at an accurate picture of what happened on September 27th or 28th of 2004 if you don't account for all of the evidence, if you don't see how it all fits together. And here's what happened. Brad Compher, at some point before the 28th of September of 2004, came into contact with Nori Jones. You'll recall that he told Detectives Collins and Bush that he had been to Job Services to use the computers. You will also recall that Doug Coffin testified that he took Brad to the house while they were working, and Brad Compher walked to the house to get a drink of water. But Mr. Coffin did not see what happened at the house. So Brad came into contact with Nori either at Job Services or at her house, probably both. You'll recall that when she was found on the morning of the 28th, her hand was curled awkwardly and her left ring finger was extended. That ring has to mean something. And at Job Services, Brad could have heard discussions about that ring, the things Jennifer Heisler and Mark Mayfield testified about. Or he could have been rebuffed by Nori herself. But when he walked to the house to get a glass of water, if he had talked to her, he would have learned where she lived. And he could have learned that she lived there alone and that she was vulnerable. So he planned what he was going to do. And just a few days before he killed Nori, he drove to her house in a small repair truck. That was the testimony of George Ratz. Well, George Ratz saw somebody drive to the house in a small repair truck. But he sabotaged the light. You'll recall that Mr. Ratz testified that he saw somebody working on that light bulb. That person had brown hair, and that person looked to be in his 30s, is what he testified to. Kevin Coffin also testified that he didn't have anybody working on the house at that time. And George Ratz testified that in the days before Nori died, it was dark around that house. Now, if you look at Exhibits 12B and 12C, those are the 10 print cards that Mr. Cushman testified about. You'll see that Brad Compher's birthday is listed above the number 3 finger. And that birthday is February 21st, 1975. That means in September of 2004, Brad Compher would have been 29 and a half years old. George Ratz also testified that this happened during the day. If Brad had encountered Nori at Job Services, he would have known that she worked during the day, and he would not have been discovered sabotaging that light bulb if he did it during business hours. Exhibit 5B. So he planned. Then on the night of September 27th or the early morning hours of September 28th, Brad made his way to Nori's house. He climbed up on the retaining trash wall, the bottom left hand of this photograph, and cut the screen with a knife or sharp object. He then pushed against the glass to get friction against the window, and he slid it open. He left a handprint. Going into the house, he disturbed the debris on the trash can just under the window. Mr. Cushman testified that it looked like somebody had stood on that trash can, and Brad also disturbed the dust inside the window and on the seat of the exercise bike that was close to the window. I'm going to note that given the fence here on the left-hand side that you can see, and the trash retaining wall, and the items that are placed between that wall and the window, this is not a natural place for somebody to lay their hand, say, when they're going to the house to get a drink of water. And if Mr. Compher drove past the house into the property before he walked to the house to get a drink of water, then that door, which would be on the right-hand side, this window would be past it, and he would have no reason to walk to or touch that window. Now, the defense may argue that we don't know this was the point of entry. But ladies and gentlemen of the jury, use your common sense. All the doors on the house were locked, and no other windows were found open. This was the only window on the property that was open when Jennifer Heisler and Mark Mayfield arrived and detectives arrived on scene. And it just happened to be behind a cut screen. Witnesses testified that the front door of the property could not be opened because of the way it was sealed. And Jennifer Heisler and Mark Mayfield testified that the back door was locked when they arrived. Detectives Collins, Stone, Daniels, and Cushman testified that this window was open, and Detectives Collins and Cushman testified that there was a handprint on it that looked like somebody had pushed against the glass to open it. And let's not forget, again, that it was behind a cut screen. Mr. Cushman was very clear about that. He testified very clearly this window was behind a cut screen. Ladies and gentlemen of the jury, this window on the left is the entry point. This is where Nori's killer made his way into the house. Use your common sense. There was no other reason for that cut screen. It isn't described by any witness as torn or worn out or ripped. 5D. It's upside down, Brian. No. One more rotation. Could you move it so they can see it? You can see there, the bottom of that screen. This screen was cut. It's evident from the photo. And you recall that Kevin Coffin testified Nori had not asked him to fix any screens on the property. And there was no testimony that this screen was cut or damaged in any way prior to September 27th or 28th of 2004. This is the entry point. If it is not, then you have to disregard the cut screen, the fact that it was open when detectives arrived, the fact that the doors on the property were locked, and you would have to disregard the disturbed debris and dust around it. If this is not the entry point, then there really isn't much accounting for all of that. This is also, when you look at it, put the first exhibit up there, please. Looking at this, this is a natural place for a person to make entry into the house. The trash retaining wall would give a strong person leverage to get in through that window. And at that entry point, we have a handprint. A handprint that multiple detectives testified appeared to have been made when the window was pushed open. And you'll recall that the handprint was swabbed by Riley Nowlin and sent to LabCorp. You heard Megan Clement testify to the DNA testing that was done on that handprint. It was done very early in 2004. LabCorp identified 11 genetic markers from the DNA on that window. But all they knew in 2004 was that whoever left that print was male. Now, very, very importantly, you'll remember that Derek Cutler testified that secondary transfer DNA does happen. But when DNA from one person is transferred to a different location by another person, you will end up with two DNA profiles. When you get back and you deliberate, take a look at Exhibit 20. That is the report from LabCorp. Exhibit 20 speaks of one and only one DNA sample from that window swab. There's no language there about a minor and major contributor. There was one DNA profile. And I'm going to note that Robert Spillett was excluded as the source of the genetic material from that handprint. Now, Detectives Collins, Long, and Harris were all lead detectives on the case. And taking their testimony together, they testified that until 2014, 10 years, they did not have a known biological DNA sample for Brad Compher. They straight up didn't have one. So that DNA profile from that handprint from that window sat for 10 years on file. Despite the items that were taken to the Idaho State Lab, of which Detectives Stone and Kelly testified, the case went cold. Detective Long described that as them having no further investigative leads or investigative avenues. They didn't find a match for that window swab until 2014, when Detectives Vanderschaft and Long recovered that cigarette butt from Brad Compher, and Long sent it to the Idaho State Lab for testing. And Cindy Hall had that LabCorp DNA profile on file. And you'll recall her testimony. She told you that the 11 DNA locations from the window swab matched the corresponding 11 locations from the DNA on the cigarette butt. And she told you the chances that anyone other than Brad Compher could be the source of that DNA is less than 1 in 93 trillion people. Now, just to illustrate the statistics here, the current estimated world population is 7.8 billion people. If you divide 93 trillion by 7.8 billion, the number you get is 11,923 and some change. That means you would have to multiply the Earth's population 11,923 times with random, genetically distinct individuals. And still, the chances that you would find any one of those people with DNA matching Mr. Compher is still less than 1 in all of those people. Those statistics are simply astronomical. And you will also recall that Ms. Hall testified that no two people other than identical twins have ever been born with an identical DNA profile at the 15 locations accepted by the FBI. Ladies and gentlemen of the jury, it was Brad Compher that pushed that window open and left that handprint. And it is simple common sense that that window was not pushed open until after that screen was cut. And that window was the entry point, and that window was the entry point was evident to every detective that responded to the scene that day. It was so evident that Detective Cushman had the window removed and sent to the Idaho State Lab so that he could process it under lab conditions. So you know Brad Compher entered that house with a knife or sharp object because he cut the screen to get to the window. So from that, and from what happened to Nori's body, it is common sense to conclude that he entered that home with the intent to do something with that knife or sharp object, to stab or to rape. And so when he entered that home, it initiated the stream of events we talked about earlier. Now, there isn't any evidence as to whether she was asleep or awake when Brad found her, but you'll recall that Detective Bush testified to seeing knife marks in the comforter. You'll also recall from Dr. Scommel that Nori was stabbed several times on her head, trunk, arms, and legs. She was stabbed 17 times alone on the trunk of her body, which suggests to you that she was lying down under her comforter when the attack began. I say it rhetorically because I can't I can't guess what the defense is going to argue. So rhetorically speaking, they may argue that the Y chromosome DNA doesn't prove much. They may tell you that any person in the defendant's paternal line would share that genetic profile derived from the Y chromosome that is passed from father to son. It's true that fathers and sons share the Y chromosome, but make no mistake. The unequivocal testimony from Derek Cutler was that the DNA he found in his testing matched Brad Compher's DNA. For that reason, he testified his findings were significant. Now, don't get sidetracked on this issue. Don't get bamboozled. It is the DNA on the window that tells you it was Brad Compher that went into that house. So don't assume that the different statistical calculations that they do with the Y chromosome testing calls into question the identity of Nori's killer. Clearly and unequivocally, Nori was killed by a knife or sharp object. And clearly and unequivocally, the window screen was cut with a knife or a sharp object. So it is common sense that whoever cut that window used that same knife or sharp object on Nori. And the person that cut that screen from the handprint was Brad Compher. The Y chromosome DNA is important because it tells you what Brad did to her. The full profile DNA taken from the window swabs tells you who left that palm print when the window was opened. And again, the statistical odds are 1 in 93 trillion, less than 1 in 93 trillion. The Y chromosome DNA tells you how that stream of events played out after Brad entered the house through that window. Exhibit C, there's 6E. Let's talk about the right hand fingernail clippings first. You will recall from Derek Cutler's report that he got an inconclusive mixture from the left hand fingernail clippings, but got a major profile and a minor profile from the right hand fingernail clippings. And that major profile matched Brad Compher. Now, why would that be? Exhibit 7C. And this is a difficult photo. These are photos of the injury sustained on Nori's left wrist. You'll recall that Dr. Scommel testified this tendon here, depicted in this photograph, was partially cut, and that her left hand would have been rendered unusable at the time that she sustained this injury. Now, Exhibit 41. This is a photo of Nori's right hand and wrist that was taken at the scene. She didn't sustain that same kind of injury to her right hand. You can also review the autopsy report. So the reason that DNA ends up under her right hand fingernails is because that was the only hand she had left after sustaining the injury to the left wrist to defend herself. She only had her right hand at that point to scratch and claw at her attacker. And that is why that DNA ends up under her right hand fingernails. And it matched Brad Compher's DNA. That is because Brad Compher is her attacker and her killer. Now, Exhibit 2, and this is difficult. This is particularly important when you look at the crime scene. These exhibits show how Nori's body was found. Now, looking at the mattress pushed up against the left wall, looking at the amount of blood at the scene, and looking at her position, it's clear that there was a struggle here. Now, Exhibit 6. And you have to ask what that struggle was about. Ladies and gentlemen of the jury, there isn't much way around it. I can only describe the position of Nori's body here as sexually vulnerable. She is naked, on her stomach, her legs pointed to the foot of her bed, and her vagina is exposed. You can take that one off. Which brings us to the anal and vaginal swabs. You'll recall that Derek Cutler testified that in instances where no male DNA was found in the epithelial or skin fraction of the sample, but was found in the sperm fraction of the sample, that is a strong indication for the presence of sperm. You'll also recall that he testified the sperm cell is more durable than the protein they look for when testing semen. So it's possible that that protein broke down before they could test for it, but that the sperm cell survived. When you couple that fact with the way Nori's body was found, it's very clear what happened here. Other than her mouth, the anal and vaginal swabs were the only items that returned a sperm fraction. Compher's DNA profile could not be excluded from the oral swabs, but his DNA matched the sperm fraction from the vaginal and anal swabs. Why these three areas? You'll also recall that Dr. Scommel testified the swabs would have been inserted into the anal and vaginal cavities. And Detective Daniels testified that he saw the swabs applied at the autopsy to Nori's anal and vaginal cavities. That's the terminology he used. It doesn't take a rocket scientist to figure out why a sperm fraction would only be detected at these locations: the mouth, anus, and vagina, and would be detected nowhere else. There was not any injury to the anus and vagina, as Dr. Scommel testified, but he also testified that rape can occur without injury. Exhibit 1. This is the ring that was found at the scene. It was bloody when it was found. When it fell to the ground, you remember Detective Bush testified that it made that ting sound as it hit the ground and he collected it. I told you earlier that the ring has to mean something. By the time detectives arrived on the morning of September 28th, rigor had already set in. This may explain why her left hand was found with that left ring finger extended. You'll also recall that Detective Collins testified that it looked like the ring had been removed from that finger and had squeegeed some of the blood from it. Exhibit 7D, please. And move it a little bit to the left for that glare. No, other way, sorry, my left, right there. And again, you can see what Detective Collins is talking about here. If you look at that left ring finger above where she would have worn that ring, that portion of the hand is cleaner in terms of blood than the rest of the hand. And again, Brad Compher's DNA matched the DNA found on this ring. You know that he went to job services, and if he had been at job services for a significant amount of time, then the chances are pretty good that he heard some fuss about this ring. That ring was removed at least some point after Nori started bleeding. And that her finger remained extended after it was removed could be explained by the fact that rigor had set in. So why would he remove the ring? It's hard to say. But there may have been something about that ring and what she was saying with that ring that made Brad Compher angry. Or it could have been a souvenir he thought about keeping before he thought better of it and discarded it at the scene. Now, a little bit about that Y chromosome DNA. In his cross-examination, Mr. Fry went right to the probabilities for the profile found on the ring, which was the weakest of the probabilities that Mr. Cutler reported. And when you get back there again, look at Mr. Cutler's reports. Those are Exhibits 25 and 26. His report states that as to the anal and vaginal swabs and the right-hand fingernail clippings, Brad is more likely to be the source of that DNA than any randomly selected male from the reported populations. That's 304 times more likely for African Americans, 106 times more likely for Caucasians, and 177 times more likely for Hispanics. But let's make sure we understand what these probabilities mean. You heard from Mr. Cutler and Ms. Hall about the kind of testing that was done. The probabilities on the Y chromosome has to be different because the Y chromosome is a different location along the genetic strand, and it is shared from father to son. But you know that Mr. Compher has no paternal brothers from the testimony given by Scott Long, and you know he doesn't have an identical twin. What those probabilities tell you is that that DNA is much more likely to come from Brad Compher than from any randomly selected male in those populations. It's much more likely to be his. And let's be clear about something else. In the testing that Ms. Hall did, I'll refer to it as the full profile testing, the testing from that window swab, she looked at 16 specific locations along the genetic chain. Those locations were not on the Y chromosome. Mr. Cutler looked at different locations, specifically along the Y chromosome. So taken together, the two sets of testing confirm each other. They tell you that Brad's DNA was a match at two completely different sets of locations along the genetic chain. In reality, the Y chromosome DNA gives you the second, third, fourth, and fifth biological markers that place Brad Compher at the scene. And that DNA was recovered from in and on her body. The sixth biological marker that you have placing Brad at the scene of the fingerprints on the back door. I wish we could have had Mr. Cushman with us to explain better than the way we had to do that. But the parts of his testimony that I would ask you to consider can be summarized as follows. He testified that he arrived and processed the back door of the residence. You'll recall that Jennifer Heisler and Mark Mayfield testified that the door was locked when they arrived, and you'll recall that there was a blood transfer on that door shown in Exhibit 38. Go ahead and show Exhibit 38. That's the blood transfer from the door. And now Exhibits 11J, 11I, 11C, 11M, and 11B. The prints in the photographs from 11J, 11I, 11C match the number 7 finger of Brad Compher from the 10 print cards. From both. You'll remember there were 2 10 print cards, one with the name Brad Compher, one with the name Ralph Compher. And Mr. Cushman testified that meant Brad and Ralph Compher were the same person because they had the same fingerprints. He also told you that the prints photographed in 11M matched the number 3 finger of Brad Compher, again, from those same cards. 11B also shows the print that was later identified to the number 3 finger of Brad Compher from those same 2 cards. Now, Randy Parker testified very clearly that no 2 people have ever been found to have the same fingerprints, not even identical twins. And you have 2 witnesses now, Mr. Cushman and Mr. Parker, telling you that these fingerprints match Brad Compher's fingerprints. Mr. Parker also pointed out that distinctive scar that appeared on the prints at the scene and also appeared on the 10 print cards. Cushman testified that to place those prints where they were placed, the right hand would have been on the edge of the door pointing out. Put those photographs back up. That one right there. Raise the bottom one. As depicted in that photograph on the bottom. And the left hand would have been pointed down on the inside of the door. And because those fingers from the right hand were on the edge of the door would have to be open when he touched it. Exhibit 4D. Cushman also testified that because of how the fingers were laid against the door, their direction, and which hand and fingers the prints came from, and because of the layout here, look at the steps going down and how the door opens over those steps. Compher would have been standing inside the door when he left those prints. Cushman understood this because to do it from outside the door would have twisted the arms in such a way that it would have hurt to lay his fingers that way. So it is a matter of common sense that Brad left these prints here while he was standing inside the residence. And this is the same door with the blood transfer depicted that we talked about earlier. And that was found on the edge of the door, that blood transfer was. An area that you know Brad touched. And he must have locked the door behind him when he left. Now, Brad Compher had two opportunities to explain these fingerprints to Detectives Collins and Bush. He met with them twice. He was informed that his fingerprints were found at the house, and he was asked why that would be. And you'll remember that Detective Bush showed him a photo of the house. On both occasions, Brad Compher told them he had never been to that house and he had never met Nori Jones. You'll also remember the testimony of Doug Coffin. It was rather unforgettable. Doug testified that when they were at the property, Brad went to the house to get a drink of water. When I asked Doug if it would surprise him if Brad had said he had never been to that house, Doug responded, yes, because that would be a lie. Ladies and gentlemen of the jury, guilty people do guilty things. They act like a guilty person would act. You should and you can consider that. We have a term for that in the law. It's called consciousness of guilt. Brad Compher was given two opportunities to explain those prints to detectives, and on both occasions he said the same two things. He had never been to that house, and he had never met Nori Jones. So why? Why wouldn't Brad Compher explain to those detectives why his prints would be there? It would be very easy to say, yeah, I was at the house, I went there with Doug Coffin, and I went to go get a drink of water. It's easy to say that. So why wouldn't he say that to those two detectives? Because when he talked to Collins and Bush on those two occasions, he knew very well what else he had done in that house. And this was 3 years before Long and Vanderschaft would recover that cigarette butt. So he said he had never been there in an attempt to still cover up what he did in that house in 2004. Guilty people do guilty things. And Brad Compher killed Nori Jones in the perpetration of her rape and in the stream of events that began when he entered that window. Your Honor, I'll save the remainder of my time for rebuttal.
Thank you, Mr. Radford. Mr. Proctor.
Thank you, Judge. Judge, kind of a nervous pacer. Do you mind if I do it from the well of the court?
That's fine.
Thank you. Good morning, ladies and gentlemen. The state has proved to failed to prove Mr. Compher's guilt. The evidence is insufficient, and it is your duty to acquit him of this charge. Now, Scott, Riley, and I, it has been our honor to represent Mr. Compher in this most serious of cases. And let's talk for a little while about what the evidence is and the significance we draw from it. To preface all of this, as Judge Gaviola told you, what we say, what Mr. Radford says, is not evidence. And also, I'm going to tell you what I remember the testimony being. Mr. Radford certainly told you what he remembers the testimony being. It doesn't matter what we remember. Well, it's your recollection that controls. So if I say something that isn't what you heard, ignore it. And if Mr. Radford says something that isn't what you heard, ignore that too. It's your recollection that controls. Now let's get the boring stuff out of the way and talk about the jury instructions. If you don't find Mr. Compher caused her death, we're done. The jury instruction number 15 says the defendant killed Nori Jones. If you don't find that, we're done. We don't have to worry about burglary. We don't have to worry about rape. And that's what you should find. That's what we submit. So burglary. Burglary is entering a premises with the intent to commit another felony therein. And what's important is it has to occur at the time of entry. If you invite me over to your house and I walk in the door and then later you go to the bathroom and I steal your phone, it's not a burglary because when I came in I had no plan to do that. It happened later. Whereas even if you open the door and let me in and my plan is I'm taking your phone, the first chance I get, that is a burglary. That's the difference. Rape. Penetration and overcoming by force. We'll talk about that in a minute. What's important and what I want you to bear in mind as we're talking about this in general is every element applies. You can't say, yeah, her will was overcome by force. That's beyond a reasonable doubt. But I'm not sure about penetration. The jury instructions are and, not or. You have to find every single one. So the overarching principle of all of this is beyond a reasonable doubt. What's beyond a reasonable doubt? As Judge Gaviola told you at the start of trial, a reasonable doubt is a doubt based on reason and common sense. It is the kind of doubt which would make an ordinary person hesitant to act in the most important affairs of his or her own life. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. You know the examples lawyers always use is marriage. So let's talk about that. Let's talk about whether you should walk down the aisle with the state's case. And we submit there are plenty of reasons not to do so. Let's talk about the evidence the state highlights. Start with the fingerprints. Doug Coffin came into court. I don't think anyone's saying he's lying. Frankly, I think the man has no filter. And he wouldn't know how to lie if he tried. So what does he say? It was a hot day. It's fair to infer that that was summer or close to it. Brad was thirsty. They went over to the house because he kept some stuff at his brother Kevin's house. And Brad said, I'm thirsty. Doug said, go over there and get a glass of water. Most reasonable thing in the world. And if Doug was lying, he'd say, yeah, I saw him go in, and Nori opened the door, and then he came back. He didn't say any of that, because he was telling you the truth. I wasn't there to watch Brad get a glass of water. I was there to pick up some lumber, look at the car, something like that. I just remember he was thirsty, and when he came back, he wasn't thirsty anymore. So, is it reasonable to assume that that's how the fingerprints got there? Sure it is. I looked, and all the doors in this building open the other way. Excuse me, Mr. Radford. But the fingerprints, more or less, were like this, except reversed because the door opens the other way. You got the left hand right about there, and one of the fingers of the right hand right about there. How do you do that? You're walking out the door. Thank you, ma'am. That's what the testimony is. That's what you heard. And the testimony was also that fingerprints stay there indefinitely unless they're wiped on by something like bleach. Do you remember that testimony? So here's the question. When was the last time you wiped on the door jamb in any of your houses? I don't know about you, but since the day I moved in, maybe. And I've been in that house 10 years. It would be more surprising if his fingerprints weren't there. And Judge Gabriola told you to use your common sense, and that's a prime example of it. Of course his fingerprints were there. And by the way, we'll get to this in a minute. The other important thing about the fingerprints is there was no blood on them. If he committed this crime, if he stabbed Nori brutally, repeatedly, in the hand, and the neck, and the chest, pulled the ring off, remember that testimony? The blood was like smeared, like the ring was pulled off. You should have blood on your hands. When you're going out that door, and he wasn't coming in the door because of where the fingerprints were, there should be blood on those fingerprints. There is not. Why doesn't he have any fingerprints in the bedroom? A door leading out? Why are there no fingerprints in the bedroom? You know, for the state's version of events to be true, there's no fingerprints on the window. There's no fingerprints on the ledge. There's no fingerprints on the bicycle seat. So I guess he had gloves on as he climbed in. And then he goes into the bedroom, and all of these things happen. And there's no fingerprints there. So I guess he kept his gloves on. And then he removed them to walk out the door, somehow keeping blood off everything, but put the gloves back on again to lock the door behind him. Doesn't make sense. The fingerprints, they really don't show anything. He was over there, he got a glass of water, big whoop. DNA. You know, DNA, this case uniquely highlights what's good about DNA and what's bad. It just does. It's not a magic bullet. We've all seen too many CSI shows. So what's good about DNA? That's his DNA on that window. One in, however, 11,000 times the population of the Earth, like Mr. Radford said. We don't dispute that. I'd look nonsensical to argue otherwise. That is absolutely his DNA on the window. How did it get there? You heard testimony that that outside door is like different from the house, like there's an internal glass door. You wanted a glass of water? Knocking on the door, not getting any attention, walk around to the side, which is closer to that door. Excuse me, can I get a glass of water? That's exactly how it got there. You know, the state says the window's the natural entry point. We don't agree with that. If you recall a few things, Doug Coffin said the door was like jiggled, like it was, or Kevin Coffin, excuse me. The door was jiggled, it was loose. Why was that? And that window is closer to the roadside. The back door is private, it's around the back. And the window, the testimony was just had two lines. But the middle part still had dust on it. So, I guess he vaulted. Mr. Radford mentioned the fingerprint cards. One of those fingerprint cards, Mr. Compher, was 220 pounds. He's no Mary Lou Retton. And the exercise bike. Mr. Radford just told you, the person who entered, the dust was disturbed on the exercise bike. Why aren't his prints there? That's the way it came in. Why are they not there? Dust is a great surface to lay your hands down on and leave print. So that's the good DNA, that it was his touch DNA on that window. And we don't know how long the DNA had been there. there for, and we don't know how it got there, and it's on the outside of the house, certainly not on the inside. That's the good. So let's talk about the bad DNA. That it's not a magic bullet. That it doesn't solve all of our woes. They keep calling it sperm, but it isn't. Dr. Scomo, 2 days later, not 10 years later, 2 days later at the autopsy, I looked for sperm, I didn't find any. Nylene, Nylene, I think was her name. I looked under a microscope. I conducted 3 separate tests. I didn't see any semen. And by the way, at the autopsy, they also looked for damage. Right? They looked at the vagina and the anus, and they saw, quote, no bruising, tearing, or contusions. None. You know, and Rio testified that Nori was not sexually experienced, and she'd certainly not had any anal sex. Wouldn't you expect it to be there? They saw no evidence at all of any bruising or contusions there at all. They saw no semen when they looked. Only 10 years later, and Cutler can't even say it's semen, it's reasonable to assume, is what he said. We submit it's not reasonable to assume. The fingernails. There were 4 nails present on her left-hand fingernails, a minimum of 4 nails. Now, Mr. Radford talks about how her left hand is inoperable. That's pure conjecture. We don't know in what order any of those cuts occurred. He says that because it doesn't suit him that Mr. Compher's DNA was not there. And by the way, the fingernails, they clipped them, they sent them off. They can't even say if it's on the outside of the fingernails or the inside. If it's on the inside, that means one thing, right? You're scraping at them, you're clawing at them. It's on the outside, it means something completely different. And no one can say that. They also can't say, because we asked them over and over again, that that's Brad's DNA. Consistent. Mr. Radford keeps saying it was a match. It was a match. No, it wasn't. It's consistent with Brad's DNA. It's consistent with Brad's male lineage. Mr. Radford mentions he only had 2 half-brothers. All right. You got cousins on the male side? Does his dad have brothers? Does his grandfather have multiple male children? We just don't know. We didn't look. It's consistent is the best we can say. And I want to talk about contamination for a minute. They were carrying the body out, the ring fell, landed on the ground. Someone heard it, they picked it up. Here's what's important about that. Same people that picked that up are the same people that noticed the palm on the window. And the testimony was, sometimes they changed gloves, sometimes they didn't. If you find the crime scene in this case was chaotic, was a mess, they're going around cross-contaminating as they go. The kitchen where they found this ring was the same ring he was in getting a glass of water, and that ring was rolling across the floor. Now, Mr. Cutler, let's talk about him for a minute. The lab with its credibility problems. In this case, there were errors. Now, he said they redid it and they tested it, but in this very case, they found errors when they ran their processes. Again, he can't even say that it's Brad's DNA, or when it got there, or that it's sperm. Can't say any of that. He said the reason he couldn't say it was sperm was because he hadn't been asked to visually confirm. Why not? How long does it take to grab that little slide, put it under a microscope, and look at it 1,000 times bigger? Why not? I'll tell you why, because Riley and Ireland did it. They didn't see it. Why give the defense more evidence by getting the same result again? Now, Brad, use your common sense, is Caucasian, right? So the odds are right around 1 in 100, 1 in 103, something like that. Even Mr. Cutler called it at the lower end of the significance. Now, also those odds of 1 in 100, those are the odds of the United States as a whole. Near me, there's an Amish community, 45 minutes up the road where I live. If you took a DNA of the average Amish person, the odds of that in America could well be 1 in 100 or 1 in 500. But it's 1 in 2 for a small insular community where everyone's related some way or other, going further up the line. So what are the odds in this community that DNA is pretty common? We don't know. This is not New York City where people move for a year or two and go. What are the odds here? That's what we need to know, and we don't. Which is to say, we have a reasonable doubt. Now, the single most troubling piece of evidence for the state's case, the single most troubling piece of evidence, is that they find at least 2, what they called sperm, in her vagina. At least 2 male contributors. So here's the question, folks. Who's the other one? It wasn't Rio. First of all, because he told you they infrequently had sex and he used a condom. And second of all, because his DNA went to the lab. So who's the second one? I don't mean to suggest that Miss Jones was promiscuous or anything like that. Far from it. She was a devout young lady. She was a modest young lady. That was all the testimony. So whose is the other DNA? Who's the other sperm portion of that DNA? I'll tell you who. It's not anyone's. She wasn't promiscuous. She didn't have a bunch of sex. They messed up the crime scene. That's how it got there. That's the only reasonable explanation. And if they messed that up, this whole DNA evidence you've got in front of you is nothing more than a facade. They missed the ring. How the heck do you miss a ring in a bedroom when you're experienced police officers? How do you miss that? That was being carried out and fell and rolled on the kitchen floor. Why isn't Rio's DNA there? It was on the necklace. It wasn't in the oral swab. You didn't give her a goodnight kiss after Monday Night Football? The evidence in this case is so deeply flawed. And former Dr. Scomo testified he didn't change gloves between the vaginal and anal swabbings. Why not? You heard about transfer DNA. Riley asked the question about, I give you this cup, you take it away, you set it down. Hours later, my DNA's on your hands, even though you and I have never met, never shaken hands. So why didn't they change gloves between the swabbings? It just makes sense. The people that found the window, that noticed the window, that saw that palm print with the touch DNA there, are the ones that handled every other piece of evidence in this case. And Ms. Rifle testified that the sexual assault kit in this case was, and I'm quoting, erroneously marked as destroyed. The system said it was destroyed and it wasn't, they messed up. That's the kind of evidence you're being asked to rely on. People that don't change gloves, vaginal sperm mysteriously appears from Lord knows where, and an evidence control that marks key pieces of evidence is lost when they're not. The comforter had 3 DNA male contributors. None of whom they can say it's Mr. Compher. Who was that? They can't say it's Mr. Compher, so I guess he hovered in midair as he was stabbing her. And that comforter, there were 5 puncture wounds in it. So we know the killer touched that as he's stabbing. Why is Brad's DNA not there? The scars in his arms. Let's talk about that for a minute. He had scars in his arms 10 years later. Big whoop. Most of us that have been around long enough have a scar or 7. It shows how much they're stretching. They think that's probative of anything. But if you believe it, right, that he got these scars because Nori fought for her life, his DNA should be everywhere. You ever get a scar that didn't bleed a lot? Not me. Steve Stone testified there was blood around the doorknob. Remember that testimony? The door was locked. So we assumed the killer locked it on the way out, which would make sense for blood around the doorknob. Why didn't they test it? Why don't we have that evidence of what was on that doorknob? It's still an evidence. We submitted, I think it's 5 L's, the evidence, total list of evidence recovered in the scene. Look, and you'll see a doorknob. Why don't we have that evidence? Wasn't Nori. All the evidence is she was stabbed and died in bed. It was the killer that touched that doorknob. Couldn't be anyone else. Everybody else testified that they didn't touch any blood. They went out of their way not to touch any blood when they went in there. Wasn't them. The police officers testified the door was open. They kept the door open as they walked in and out recovering evidence. Who's that blood on the doorknob? Who put that blood there on the doorknob? Scott Long told you he took 5 pieces of evidence to Sorensen. So let's talk about what he didn't take, which again is in the evidence log. He didn't take cigarette butts lying outside. You heard testimony they got Mr. Compher's DNA from a cigarette butt. Why didn't they test those? They didn't take pillows. Why not? Everybody sleeps on a pillow. Reasonable to infer she was attacked while there was a pillow nearby. They didn't take the sheets. Why in the heck not? I'm sorry they didn't test the sheets. Why in the heck not? There was a struggle. They rolled around. They can find Mr. Compher's DNA from touching a window. They can sure as heck find the killer's DNA from a sheet. They took the carpet. Why didn't they test that? Mr. Cushman told you they took the carpet. Why don't we have those results? They took the bedspread with 5 puncture wounds. Again, we know that the killer touched that. Why don't we have those results? They took towels. Same questions. They combed her pubic hair. Same question. Why didn't they analyze those? They took hairs under her nails. Why not look at those? Tell us whose hair that was. You name it, they took it, they didn't test it. That's beyond a reasonable doubt, folks. That shows what we're lacking. So let's talk a little bit, see how we go for time. Not bad. About Mr. Compher. Brad, could you stand up, please? This is Brad Compher. You know, thank you, Brad. I always feel like it's easy when we have objections and witnesses and arguments to forget why we're here. Doug Hoffman told you he's a hard worker. It's true, you'll have Brad's statement that he said he didn't know Nori and he didn't know the high school pole line. Couple of things. It was 7 years later. I don't remember last week. And when he was over there with Doug, he wasn't there to go into the house. He was there to help with wood or work on a car. I don't think Doug could remember which. He wasn't there to go to that house. He wasn't there to meet Nori. Is it really so incredulous that 7 years later he didn't remember? He told, and you will have back there Mr. Compher's police interview. I encourage you to watch it. He told him he had problems with memory. Frankly, I don't have problems with memory, and I wouldn't have remembered it either. He met her for maybe 30 seconds total. How long does it take you to pour a glass of water and hand it to someone? If that. All right. Now I want to switch gears and talk about Robert Spillett, Bob Spillett, cowboy. He's been called all three things in this trial. First of all, we don't have to prove anything. It's not our job to prove that Robert Spillett committed this murder. What I would say, though, is if you have a doubt that Mr. Spillett might have been involved, by definition, you have a reasonable doubt that this guy was involved. That's the significance of this the testimony there. He was in his 30s around that time, which, you know, the state just talked about how Mr. Compher was 29 and a half. So what? Bob Spillett, he's in the ballpark too. You know, the state talks about how Brad may have encountered Nori at job service. First of all, he said he was there to look at the computers, and the testimony the computers were in a different place. But even if he was, so what? Certainly, Mrs. Compher didn't freak her out. There's no testimony she told her coworker she was worried about Brad Compher. There was no testimony that he asked her out to dinner or breakfast. There was no testimony that Mr. Compher wondered if she had a double life, wanted to marry her. Despite never even being on a date with her, he wanted to marry her. He was fixated. He'd been served with divorce papers just a few weeks earlier. He'd identified his next willing victim, and that victim was Nori Jones. He hassled her at work. That's a testimony from at least 3 people. Bob Spillett hassled her at work. Ms. Heisler, Jennifer Heisler, I think it was, testified that Nori told Spillett several times not to come to her, not to come to her specifically, and he still did. Mark Mayfield testified Spillett made her, quote, very uncomfortable, excuse me. Let me ask you this. As the judge has said, and Mr. Radford said, and I've said, you got to use your common sense, right? One thing we all agree on, you got to use your common sense. Most of you, I'm sure, have had jobs over the years. Most of you are probably working now, and your employer's wondering when this will be over so they can have you back, right? And in your jobs, every single one of you has had an unreasonable customer, an unreasonable coworker, a difficult boss. It's just, everyone has one. You know, in my office, I'm the difficult one, right? Did you ever hide in the bathroom from that customer? From that unreasonable coworker? You ever lock yourself in a bathroom the minute they set foot on the place? How intimidated, how perturbed would any of you have to be to lock yourself in a bathroom when someone comes into your office, an open public place with lots of other people around? How uncomfortable would that person have to make you? Now, Mr. Radford talks about the ring. He says something like, we'll never know the reason. I gotta guess, she bought not one but 2 rings because of Bob Spillett. She showed it to him. He was the one that was testified to that wanted to know if the ring was real or legit and what her statement was or what her status, relationship status was. There's no evidence Brad even knew she had a ring. None. You didn't hear that testified to by anyone. But there's ample evidence that that ring was designed for one and one purpose only, to keep Bob Spillett away from her. He's the one that would want that taken off. He's the one that would send the message, you better not wear a fake ring for me. Bob commented on, she treated him differently at Ridley's, the grocery store. I bet she did. And I bet that annoyed him no end. I bet he was spoiling for a fight after that. And the phone book, you remember that testimony? She lived there, I think Kevin said, for more than a year or 2, I think he said, something like that. Makes sense. We all remember phone books from the distant past. They update them more frequently than that. He had her address. It was in that phone book. And Mr. Spillett, the testimony was around 150, 160 pounds back then. That sounds like someone could jump through a window. Not 220 pounds, look at his fingerprint card. I don't think it was the window, don't get me wrong. I think it was the door, and that's why the door was jiggling and loose and shut. But if you find that testimony credible, Bob Spillett's the one that can fit through it. It also makes sense because she at least knew Bob. She's going to open the door for anyone. It would be, hey, stay away from me, get out of my hair. She might open the door for him. She ain't opening it for Mr. Compher, who she doesn't know from Adam other than a chance glass of water sometime before. And Mr. Rex, let's talk about him again. I don't think anyone's going to say that guy was lying. But what he told the cops a few days later was that the person that was fiddling with that light had sandy blonde hair. Why is that important? The testimony was that Bob Spillett had bleached blonde hair. Pretty close, right? Bob Spillett, and it's in evidence somewhere, you'll find it, had like a white truck with like a bed on it, on the back of it. And I think I asked the officer, might call that a maintenance truck, mightn't you? And he said, yeah, sure. Why is that important? Rack said it looked like a white maintenance truck that was fiddling with that light. No testimony that man even had a scooter. And here we have Bob Spillett, surprise, surprise, driving exactly the same kind of vehicle around the time that this light was, within a week or 2, or when this light was tampered with, that fits the description of Mr. Rex. Kevin said it wasn't him, Kevin Compher is, that fiddled with the light, and I bet it wasn't. Use your common sense. Walks like a duck and it quacks like a duck, it's probably a duck. Rax described Spillett's vehicle. You saw a picture of Spillett's vehicle. Sometimes 2 and 2 just equals 4. And while they talk about Brad and the scars 10 years later, who had cuts 7 days later, consistent with defensive wounds? I know who. Bob Spillett. You know, he can say that it came from a transmission. I don't know how you get them on both sides of your hands from a transmission. If you drop it, it scrapes that way, sure. If you're carrying it, it scrapes that way, sure. Both sides? Seems unlikely to me. you work at Jiffy Lube, last time I checked, Jiffy Lube wouldn't change your transmission anyway. Speaking of 10 years later, they can say it wasn't Bob all they want. 10 years later, they sent his DNA to Utah. For 10 years, at least, he was on their radar screen. It's someone they were looking at. Don't take my word for it that Bob Spillet's a viable suspect. Take the Idaho State Police and the Pocatello Police Department. Why are they sending his DNA 10 years later? Bob Spillet's dream. Let's talk about that for a minute. Officer Brennan said he had sexual in nature fantasies. Those were his words. He said the sheets were blue. Guess what? They were. He said the walls were green. Guess what? They had green print. He said she was naked. Surprise, surprise, she was naked. He said she had cuts on her leg. I'm going to go out on a limb here. She had cuts on her leg. And these details were not released to the public, which makes sense. No one publishes that. And I bet the two civilians that were in there looking for her, there's no way they took an ad in a local newspaper to describe what they saw. And they certainly aren't sharing it with Bob Spillet, who gave them the heebie-jeebies. He said these things because he was there, because he knew it. He said there was an altercation. There was. He said there was standing and pushing. Pretty clear from the photos, that's exactly what happened, right? When he woke up, he wondered if they had sex. He called the crime scene brutal. You've seen those pictures in intimate detail. All of us think that crime scene was brutal. And I want you to step back and think about it a minute. Let's say, and I hope it never happens, and it probably never will, you got a phone call that someone you used to work with died. Would you automatically go to the sheets were blue, the walls were green, it must have been brutal, there was pushing and shoving, she was lying in a prone position, she was naked or wearing white leotard? Is that what you assume? He said these things because he was there, because he knew it. You know, and the day I start having dreams about violent sex and a brutal crime with someone who just died, I'm checking myself into inpatient mental health treatment. He called it an out-of-body experience. Evidence shows it's very much an in-body experience. And if you have some doubt that Bob Spillet was involved in this, by definition, you have a reasonable doubt that that guy was. So, the state really can't have it both ways in this case. If the crime scene was good, and everyone changed gloves, and they all acted with all the care and attention that you as a jury demand, his DNA should be everywhere, and his fingerprints too. And if they cut corners, if the scene was chaotic, if people were rushing in and out, then you can't trust the evidence. Again, I just come back to that. Who else is in the sperm portion of her vaginal DNA? Who else is it? State gets to go last. Maybe they'll tell you. I don't know. You know, in Scotland, a jury gets 3 verdicts. Guilty, not guilty, and not proven. Here in America, we shortened it to 2, guilty and not guilty. But really, it's the same thing. The state's case is not proven. This is a horrible crime. I don't dispute that. No one deserves to die like that. And Nori, as best I can tell, you would have loved her to be your neighbor, your friend, your colleague, any of those things. That's not what we're here to decide. We're here to decide if they prove beyond a reasonable doubt that that guy did it. They have not. You know, come back to the marriage analogy I talked about at the front, that beyond a reasonable doubt is kind of a major thing you would do in your life, like get married. There's no way you would till death do us part with all these questions. You just wouldn't. You'd have doubts. You would not think it was going to last. They haven't proven their case. Now, I'll finish with this. Abraham Lincoln called being on a jury the highest act of citizenship in time of peace. It's really important what you're doing here today. I grew up in Northern Ireland in the 1980s, which, by the way, is the answer to your question on why does he say some words funny. But in Northern Ireland in the 1980s, we had what we called our troubles. And because of that, we didn't have jury trials. We had this abomination called deadlock courts, where one or two or three judges decided if you were guilty or not. And everyone, Protestant, Catholic, young, old, knew that was wrong. It's just about the only thing we could all agree on during those difficult times. The reason we all stand up when you walk in the room is because you're the judges of the facts. Judge Gabriola, he's in charge of the law, you're in charge of the facts. You've been told not to discuss the case. And that's right, and it's proper, and that's what you should do until after the verdict. But after the verdict, I encourage you, tell your friends about it. It's the highest act of citizenship in time of peace. Tell them about how it went, what was important to you, how you felt about the experience, and tell them the state didn't prove its case. I took an oath. I did what I was tasked with doing, held them to the burden of beyond a reasonable doubt, and I voted to find Brad Compher not guilty and send him home. Thank you.
Thank you, Mr. Proctor. Mr. Radford, you have 20 minutes.
Mr. Proctor ended with a quote to Abraham Lincoln. I'll raise him one. I'll give you a quote from John Adams, another president of the Union. He said, facts are stubborn things. And whatever may be our wishes, our inclinations, or the dictates of our passions, or our desperation, they cannot alter the state of facts and evidence. I've put that exhibit back up for you. The defendant's case rests on the idea that Mr. Compher knocked on that window when he didn't get an answer at the door to get a drink of water. Look at that photo with the wall in front of it, the trash cans behind the wall, and the fence to the left, and tell me whether if you went to this house and didn't get an answer at the door, would you go to that window and knock? Or would you pick a different window? One that's easier and less awkward to get to. That's the first portion of their defense. The second portion of their defense is that law enforcement just must have been disorganized and contaminated the crime scene. Now, they are alleging this without giving you one solitary fact, one example of any piece of evidence that was mishandled. They haven't shown you a thing about any item where the officers did not switch their gloves and were worried about cross-contamination. Detective Sellers from that stand testified to you that they were conscious of it, that they were aware of it, that they were taking precautions. Now, why would a team of seasoned detectives You heard all of them testify as to how long they had been detectives. Why would they touch a window, a handprint on a window that all of them recognized was so vital that it was collected and wrapped and sent to the lab? Why would they touch that swab? And the defense has given you, why would they touch that handprint? And the defense has given you no testimony, no evidence at all that that ever happened. That's pure conjecture. Now, the defense brought up, and we're going to get to rant Mr. Spillett, but before I close my comments to you. A couple things that I want to address from the defendants. Mr. Proctor made the argument he wasn't sure about penetration. When you look at your jury instructions, you'll see that it's not just rape, it's also the attempt to rape. If Mr. Compher killed Nori Jones in the attempt to rape, then penetration doesn't matter. He gave you this example. I'm going to step over here. You open this door. He said placing your fingers like this and like this as you're leaving after you got a drink of water would be natural. Doesn't excuse the fact it would also be natural if you just killed somebody and you're looking back at what you did. Lock the door and you close it behind you. So that really doesn't tell you anything. He asked why there wasn't any blood on the fingerprints that were recovered. Well, that's pretty simple to explain. He would have known there was going to be blood, so he brought something with him, a rag or something like that, to clean himself off. And he cleaned himself off before he closed the door, put that in his pocket, discarded it somewhere else, and it was never discovered. So don't get bamboozled with that. Asked why there's no fingerprints in the bedroom belonging to Mr. Compher. You saw that bedroom. It's carpet, it's blankets, things of that nature. Detective Cushman testified that when he processed the scene, he processed non-porous surfaces. So where in that bedroom would he have been able to find fingerprints? You're talking about carpets and blankets and pillowcases and things of that nature that aren't going to yield a fingerprint. He told you there was no fingerprint on the window. Of course, that's not entirely accurate. There was a print on the window. There was a handprint. That's what the witnesses testified to you. But Mr. Cushman, and maybe this was lost because of the way that we had to present that testimony, he testified that there was a print, but it was not good enough quality in order to pull a print from it. He couldn't use it for comparison. Now think about if you push your hands against a window like this to get friction and open it. There's going to be some sliding, there's going to be some smearing of those prints as you push to open the window. That explains why there was no usable prints from the window. And also, knocking on this window, the other thing that you have to consider is that when detectives arrived at the scene that day, they found a cut screen. He's asking you to just completely disregard that fact, that that screen was cut. And if that screen wasn't cut when he went to go get a drink of water, then knocking on that window, he would have knocked on the window and the screen in front of him. Would you get a handprint from knocking on a window? That's the testimony. It was a handprint. And facts are stubborn things. Now, Mr. Compher, or Mr. Proctor, told you that in the first handprint card, that was from 2007, that Mr. Compher weighed 220 pounds. Now, I'm going to say this. Look at that window again. Gauge it from the size of the trash can that you see here on the right. You're all familiar with that kind of a trash can. So you can look at that window and you can gauge about how big that window is. So the first point, that's plenty big for somebody that's 220 pounds and as Mr. Coffin testified, strong. That's big enough for somebody to get through. The other thing is that 10-print card was from 2007. So that was 3 years after the assault occurred. Can somebody gain a significant amount of weight in 3 years? I have done that at multiple points in my life. So his weight in 2007 doesn't tell you anything about his build in 2004. He also told you that when they did the forensic testing initially that they looked for sperm and didn't find any. That's not, I don't think, accurate. They looked for the protein that is found in semen, in the fluid. You have the sperm cell, and then you have the fluid that carries the sperm. Mr. Cutler testified to you and explained to you that that test, when they do that test looking for semen, they're looking for a protein. They're not looking for a sperm cell. That's why they didn't take semen there, because that protein had already broken down. Now, again, Dr. Scommel testified that rape can occur without injury, but as I've already explained to you, because if Brad killed Nori Jones in the attempt to commit rape, that is also first-degree murder, so you don't have to find that he actually penetrated her. I will say it again, the fact that the sperm fractions were identified only in the anal and vaginal swabs are clear evidence that a sexual assault occurred. Now, Mr. Proctor kind of attacked the DNA, telling you that all they can say is that the DNA is consistent. That's not the testimony from the witnesses. What they said is that the DNA that they recovered from the scene, from in and on Nori's body and from that handprint, matched. They said it matched. There was never any language about it being consistent. What they meant by that, if you'll look back at your notes, is that when they do this analysis, they look at specific locations along the genetic line. And they look for whether at those locations the data is the same between the two samples that they have. And again, I'm going to reinforce to you, the Y chromosome DNA looks at specific locations along the Y chromosome. The full profile DNA done by Mrs. Hall looks at different locations. So Brad's DNA was a match at two completely separate, unrelated locations along the genetic chain. And he also told you, he pointed to the probabilities for Caucasians in Mr. Cutler's report. I want to be really clear about that. Read the language. When you get back there, look at Exhibits 25 and 26 and read the language very carefully. The odds don't apply to Brad. They don't apply to Mr. Compher. The odds that he's talking about apply to that randomly selected male from the given populations. And what those probabilities tell you is that Brad's DNA, or the source of that genetic DNA, is much more likely to come from Brad Compher than from randomly selected males from in those populations. That's what those probabilities mean. He asked you why there would be two male contributors to the sperm fraction. Now I'm going to note, and this is uncomfortable, and I apologize for this, but Rio testified they had never had anal sex. Testified they had had vaginal sex. On the vaginal swabs, there are a major and minor contributor. Brad's is the major, matches the major contributor. On the anal swabs, there was only one profile. There was one sperm fraction, and it matched Brad's DNA. Now, with all this talk about the DNA, and they're getting into Robert Spillett and all these things, really what the defense is trying to do is to deflect your attention to inconclusive testing that was done throughout the investigation. They're trying to get you to think about that because they don't want you to consider the DNA evidence that has been presented. Facts, ladies and gentlemen of the jury, are stubborn things. And there is no explaining away where that DNA was found and the fact that in all of those cases we've talked about, that DNA matches Brad Compher. Now, Robert Spillett. You've heard a lot of testimony about this guy. Mr. Proctor told you that Robert Spillett would have been, in his 30s, 2004. I'm not sure that's accurate. You saw the photos of his hands. When you get back to the jury room, take a look at those. I would peg Mr. Spillett to be more in his mid-50s in 2004. Those hands do not look like the hands of a 30-year-old to me. Now, in this dream that he had, you know that he read the newspaper before he talked to detectives. And Mr. Proctor has given you examples that were some few examples that were consistent with the crime scene, but all of the other examples that Mr. Spillett gave you were not consistent in any way. They didn't bear any resemblance to what that crime scene actually looked like. There were no white leotards. She was not found at the foot of the bed. She was not lying on her back. Ladies and gentlemen of the jury, this thing with Robert Spillett was a dream. He's talking explicitly when he's talking to these detectives. He's telling them, I had a dream about this. And he would have had this dream after reading the newspaper. And what he relates to them doesn't bear any resemblance to how that crime scene actually looked. Robert Spillett was just a lonely, creepy old man who had a strange infatuation with Nori Jones. That does not make him her killer. Now, at one point the defense said the state can't have it both ways. And they asked you to consider why there wasn't any DNA found on the blanket, on the pillowcase, on the carpet, all of those things. Well, ladies and gentlemen of the jury, the defense can't have it both ways either. They can't tell you that this was done by Robert Spillett and not point to one solitary piece of evidence that ties him to the scene. There isn't one. He had Matt Harris on the stand. I asked him that question at the end of his testimony. Is there any physical evidence tying Robert Spillett to the scene? He had reviewed the case file at that point, and he said, no, there isn't. So they're trying to get you to think about Robert Spillett because, again, facts are stubborn things. They don't want you to think about the DNA that came from that handprint on the window. They don't want you to think about the fact that that handprint was behind a cut screen. They don't want you to consider that the Y chromosome DNA that was recovered from in and on Nori Jones' body matched the defendant's DNA. The doubts they have given you are not doubts based on reason and common sense. They are doubts based on sheer fantasy. When everything is said and done, the only accurate picture is this. It was Brad Compher that cut that screen and pushed that window open, making entrance to Nori's house with a knife or sharp object. It was Brad Compher that cut her throat and punctured her heart. It was Brad Compher that left his DNA in her anus and in her vagina and under her right hand fingernails. It was Brad Compher that killed Nori Jones. In that sense, ladies and gentlemen of the jury, her body is a testimony to you of what happened that night. And because of it, we, the state, ask you to find Brad Compher guilty of murder in the first degree for the death of Nori Jones. Thank you.
Thank you, Mr. Radford. All right, ladies and gentlemen of the jury, I'm going to have Ms. Holm draw two numbers at random between 1 and 14. The jurors with the corresponding numbers will be dismissed at this time, but your service is not necessarily over. In the event a juror becomes ill or excused for any reason, the alternates will need to return, and your deliberations will begin over again. All right, Ms. Holm, please draw two numbers.
Number 6. And number 1.
All right, jurors 1 and 6, you're excused at this time with the thanks of the court. However, you have to continue to abide by my admonishments. You're not to discuss this case with anybody. You're not to do any research or do any investigation regarding this case, okay? I need to get your telephone numbers, give those to Mr. Reiner so we can get a hold of you in case we need to. So again, please do not discuss this case with anyone, all right? I ask that you leave your notes in the jury room as well. All right, jurors 1 and 6.
And Your Honor, before jurors leave, we'd like to bring some, we need to approach the court.
Come on up.
Take them back now or we wait?
Now just wait. All right, jurors 1 and 6, if you would, come forward to Mr. Reiner, give him your cell phone numbers in case we need to get a hold of you. All right, I'll now ask Ms. Holm to swear Mr. Reiner.
You solemnly swear that you will keep put this jury together in some quiet and convenient place, that you will not permit any person to speak to them, nor do so yourself unless it be asked them if they have agreed upon a verdict, and that you will return them into the court when they have so agreed. So help you God.
Yes.
Very well, ladies and gentlemen of the jury, the case is now in your hands. Mr. Reiner will escort you to the jury room to begin your deliberations.
All rise.
All right, please be seated. Okay, we're on the record. Counsel for the state, counsel for the defense, and the defendant are present. We are outside the presence of the jury.
I'm sorry, Your Honor, I was talking to Mr. Andrew. I missed that question.
So we are on the record outside the presence of the jury with both parties and counsel present. Mr. Andrew?
Just, Your Honor, just wanted to put on the record what I believe was discussed at the bench in terms of our request. Our position is the court should give the jury an additional instruction regarding statements made by the prosecution. One, about there being a stream of events. Two, reference to the law on aggravated assault and grand theft, because those are statements on the law. They're not argument. It's not discussing facts. Mr. Radford was attempting to provide law to the jury, which is required, and it wasn't in the instructions. Those things are supposed to be in the instructions. The state didn't ask for those things to be in the instructions or were denied regarding those. And therefore, we think we were entitled to an instruction to the jury. It should disregard any comments by the prosecution with regard to stream of events, aggravated assault, or grand theft.
Your Honor, the state disagrees. Comments about the law have to be made in a closing argument, because what argument is applying the facts to determine whether the legal standards have been made. So attorneys in closing argument must refer to the law. And I'm just going to state for the record that this issue of the stream of events, that is the law. It's stated very clearly in two cases that have already been provided to the court. There is nothing inappropriate with the state referencing those legal rulings.
I understand the position the defense has articulated to the court. However, the court disagrees that any additional instructions need to be given to the jury. The court, in reviewing the final instructions with the juries, noted that in closing arguments, facts are not evidence. Instruction also given to the jury was that if they were told a law different than what the instruction was, they were to follow my instructions. So those instructions are already covered.
The only other thing to add, based on Mr. Proctor's comment, is that those things also were not pled in the information, so shouldn't have been referenced. So.
Understood.
The state's response is that the case law discussed talks about the perpetration, and perpetration appears in the pleading documents.
All right, I understand the arguments. The instructions as read to the jury by the court will stand. There will be no additional instructions as requested. All right, well, all of you.
Your Honor, I'm sorry. I just, wakes me up in the middle of the night. It's an appeals court saying that might be a good issue, but trial counsel failed to preserve it. So we would again renew our objection to the verdict form with, as requested on Friday, we, the jury, unanimously find for felony murder, whatever the underlying felony was. I don't anticipate you're going to change the ruling. I just want it preserved.
All right. I understand the sentiment, Mr. Proctor. You've made your record. Your request is denied. The verdict form the court has for the jury will remain as is. All right. Ms. Price, Mr. Trammell, Mr. Radford, I congratulate you on a job well done. I appreciate your professionalism and your conduct during this trial. The same goes for you, Mr. Proctor, Mr. Andrew, you, Mr. Fry. I congratulate you all on a job well done and in your representation of Mr. Compher. I think we have all of your contact information, so as soon as we get a verdict, we'll let you all know. If we don't have your number, please give it to Ms. Holm. All right, anything else we need to take up before we recess?
No, Your Honor.
No, Your Honor.
All right, we'll be in recess.
All rise for the court.
All right, good afternoon. We'll be on the record. State of Idaho versus Brad Compher, CR 2014-12727. We have counsel for the state, counsel for the defendant, and the defendant are present in the courtroom. We are outside the presence of the jury. The court's informed the jury has reached a verdict. Off the record, the court discussed with Mr. Proctor and the state's counsel whether the state, if the verdict is guilty, would be pursuing a deadly weapon enhancement or part 2 of the verdict. Court's informed the state is going to withdraw that deadly weapon enhancement. Is that correct, Mr. Radford?
It is, Your Honor.
All right. Anything we need to take up, counsel, before we bring the jury in?
Your Honor, only cautionary instruction to people in the courtroom to mind their manners regardless of how the verdict comes out.
All right. Thank you, Mr. Andrews. So, members of the public, family members, other members here from the courthouse and the gallery, I caution you not to engage in any outbursts once the verdict is read. Thank you, Mr. Andrew. Mr. Andrew, bring the jury in. Please be seated. All right. All members of the jury have returned from the deliberations, are seated in the jury box. Will counsel waive roll call of the jury?
Yes, Your Honor.
Yes, sir.
All right, ladies and gentlemen, the jury, Mr. Reiner informs you reached a verdict. Is that correct? Yes, sir. Who is your foreperson? Thank you, sir. Juror number 3. Mr. Reiner, would you collect the verdict form from juror number 3? All right, will the defendant and defense counsel please rise? Madam Clerk, please read the jury's verdict.
In the District Court for the 6th Judicial District of the State of Idaho, in and for the County of Bannock. State of Idaho plaintiff versus Ralph Roy Compher, a.k.a. Brad Compher, defendant. Case number CR 2014-12727, verdict. We, the jury, unanimously find the defendant, Ralph Roy Compher, a.k.a. Brad Compher, guilty of murder in the first degree. Dated this 4th day of March, signed by the presiding juror.
All right. right, thank you, Mr. Compher. Counsel, please be seated. All right, ladies and gentlemen of the jury, is this your verdict?
Yes, sir.
Okay. Everybody answered yes. Did anybody answer no? The record show no response. Do either side wish to have the jury polled?
No, Your Honor.
No, sir.
All right. All right, ladies and gentlemen of the jury, I have one last instruction for you. This is instruction number 26. You have now completed your duties as jurors in this case and are discharged with the sincere thanks of this court. The question may arise as to whether you may discuss this case with the attorneys or with anyone else. For your guidance, the court instructs you that whether you talk to the attorneys or to anyone else is entirely your own decision. It is proper for you to discuss this case if you wish to, but you are not required to do so, and you may choose not to discuss the case with anyone at all. If you choose to, you may tell them as much or as little as you like, but you should be careful to respect the privacy and feelings of your fellow jurors. Remember that they understood the deliberations to be confidential. Therefore, you should limit your comments to your own perceptions and feelings. If anyone persists in discussing the case over your objection or becomes critical of your service, either before or after any discussion has begun, please report it to me. Ladies and gentlemen of the jury, I give you my sincerest thanks for your service. You are excused.
All rise for the jury.
Please be seated. All right, on the record, jury has been excused. We have counsel for the state and defense and the defendant present. All right, Mr. Compher, you have been convicted of murder in the first degree. Pursuant to that, the court's going to schedule sentencing for April 30th, 2024 at 9:30 a.m. Mr. Compher, the court's also going to order a pre-sentence investigation report to be completed, a process for which you will have to comply. Do you understand that, Mr. Compher?
I can't really talk right now.
Okay. I'm going to notify you again, the pre-sentence investigation will be part of your sentencing procedure, and we'll have a copy of that report provided to you and your attorneys in advance of the sentencing hearing. And anything else we need to take up, counsel?
Not from the state, Your Honor.
No, Your Honor.
All right. The court will be in recess.
All rise for the court.